So we're a section behind because of the couple of snowstorms, so we will catch up by the end of next week. Not going to catch up entirely today, obviously. But let's talk about the Pier 4 case. It's an interesting case to me because there's an awful lot going on, and it starts really with us looking at 93A, which is protects both businesses and consumers from unfair and deceptive trade practices. And it's one of the state-tested subjects on the bar examination as well. So it's important to be familiar with what the requirements are and what its remedies it provides. And especially if you're going to practice in Massachusetts, it becomes especially important because it's a statute we use quite often because where it does provide for double or treble damages plus attorney's fees. In the real world, if we can plead a 93A claim, we do because it gives us some additional leverage in trying to settle that case, and if we can't settle it and we have to try it, it gives us an opportunity potentially to be able to get double or treble damages plus attorney's fees from the time you handled the case through the conclusion. So it's a significant remedy that's used in the real world as well. But you read the case, and there's a bunch of interesting things going on here. The first thing is that this is a jury waived trial, which is kind of interesting. First of all, 93A claims do not have the right to a jury trial, so there were contract claims that would have been entitled to go to the jury, but 93A claims, as a matter of the statute, don't have the right to go to jury trial. And you read the case. It's about a contract case. I guess where I want to start is, so Anthony comes to you and he says, listen, I made a bad business deal and I want more money, or I want to breach the contract. Or I don't want to breach the contract, I want you to find a way to get me out of the contract. That's your job? That's it?
Yeah.
He's got the money. He wants you to go into that contract, find a reason why he doesn't have to perform, and we're good with that.
It's your job.
No,
That's your job. Huh?
No, you got to tell them, listen, your kids will be okay at $175,000 a year, or whatever they're getting.
$750. A lousy $750 is the language, right?
You got to talk them down and say, look, you made a contract. I realize that
his kids were only going to get a lousy $750 a year.
Poor kids.
So you're going to tell him, no, Anthony, that's wrong?
You got to ease them, see if you can ease them down, and if he really wants to go through with it, then yeah, of course. But
Women, yeah, of course. What? So you're going to say?
Of course, representative, if he's adamant about to be like, no, I don't care, I'm going to find somebody, if you don't do it, I'm going to get someone else. Then
Well, he's going to get someone.
Someone will do it. There's enough greedy pigs out there like him, and there's enough lawyers out there that will do that for him.
And so might as well be you.
Yeah, exactly.
Because he's got the cash here, right? Let's make no bones about it. He is a powerful, financially set individual, and you can pull this off for him. You've married a client, made a lot of money.
Big client.
Huh?
Big client.
A big client, no doubt about it.
Yeah, but then when you lose, you know what I mean, your name goes out there, so you got to be careful, at least warn them, and say,
Well, but so tell me what the plan is. You are gonna take as much. Is anyone not gonna take? Anyone gonna push the pile of money back and say, this would be wrong? Really, you should honor your agreement. You made a deal. In fact, you just.
Yeah, I would warn them. I would definitely say, look, this isn't a good, if I thought it was not a good case, say, look, you don't have a good case yet. If you absolutely want to go through it, of course I'll represent you, but I think he'd respect you more, and who knows, maybe you get the business down the line.
Well, what do you guys think? I mean, because here's the thing, is he's going to give you the contracts, he's going to say, find a way out, right? And you're lawyers. That's what you do, right? We say, hey, look, what about this? Matt, that's...
Well, maybe he could make more money by breaching, and that'd be a good sense breach.
So if he wants to breach, you're there to help him, and that's his business decision as to whether it's more profitable for him to breach or spiteful. I mean, some of this just reads like, I don't care. I'm not going to take a bad business deal where these guys are going to make a fortune.
No, I was just commentating.
Go ahead. What were you going to comment on?
I really forget. I'm so sorry.
Okay. So women, there's no one pushing the money back, just to be clear. Because you are fabricating a reason for the breach, right? Matt says, well, I'll find a reason for the breach, or worst case, we breach, and hopefully he'll figure out a more financially advantageous way to sell this land. But
I think that once you tell him, this is not going to look good, this is not, you're probably not going to win, I think he'll go look for another attorney that will incentivize him and give him a better outlook of it.
well, he may want someone more positive. Go ahead.
He may actually make more money by breaching, so it might be in his interest to do so.
So is that you're all good with that though? So whatever the client wants to do, they bring us the deal, and either I find or make up a reason to breach the contract, to say no, you know what, screw it, we're going to breach it. We don't care. Sue us if you like. We're prepared to defend.
As long as it's not illegal.
Yeah.
What's that mean? As long as it's not illegal? I mean, you are. My understanding is what's that mean? Because you're breaching the contract, which means, as Matt says, that means you're violating the law. Well, that's illegal. No, I mean, is that what you mean by illegal, or as long as the police can't come in and haul you away, we're good to go? The latter is the standard. So, is it? Because clients come in a lot of times and they have a deal they don't like. I want to make it better. I want to do this or that. But our job is just to do whatever they want. Because you can see what he wants, and he wants it simply for business purposes, right? He wants more money. And
If you can find a way in that contract to get him out, well, then that's your job.
so you're the deal breaker. Because that is what people tell us.
That's what he wants you to do.
That's what they call us. Right? We're not deal makers, we're deal breakers.
You're
We
whatever
put
you
barriers
want to
in the
be.
way. Right? And that's what your job is. Anthony wants, and I'll apologize for the rude language, Anthony wants a ball buster lawyer who's going to go flat out and try to crush HBC here. Whatever it takes, get me more money. And you're all in. After we caution him, you can lose, but I'll take that 25 grand from you.
But doesn't that happen all the time? You make a contract and then you find out, okay, it's no longer viable for you, lucrative for you, so you try to find a way out.
I would vehemently caution him.
But so that's your job. If that's what they want, you're out. You don't think so?
I think it's easy to sit here right here and say, oh yeah, I'm gonna go for it, but I think along with this, there's only certain parts that you get to read in these cases. Like, the lawyer could have been crossing that ethical boundary knowing that the lawyer's gonna know what his real reasons are for breaking this contract. Just to say that I wanna break it because it's prosperous for my business doesn't mean there's no repercussions for that.
Well, that is at least I assume part of the discussion you're going to have, and explain to him his exposure on this deal.
But isn't that why you enter into the contract? Because you think it's prosperous for your business? So if that's the reason to get into it, and then you figure out if it's no longer prosperous for your business, shouldn't you try to get out of it?
I don't know. I'm just wondering, I'm wondering what your job is here. So your job is then to go through that contract with a fine-tooth comb, try to manufacture reasons why he's not in breach.
Manufacture is a
Strong word.
strong word. If there's something in there.
But that's what you're doing here, right? I mean, you read the case, you read the reasons. You are manufacturing a reason why your client's not in breach.
Well, there was a reason in there.
Oh, that he didn't actually sign off on the dotted line about approving the plan, right? I assume that's what you're talking about.
Yeah, it's a technical.
Yeah. It's a technical breach, but God bless us lawyers because we found something, right? That's your job. Even though there's videotape that says he's just effusive in his praise of the design, okay, that's a videotape. It does require a writing, and I never signed.
I mean, that's what you got. You have to run with it.
You do.
You know,
You
caution
do.
them that,
You caution them that what? That's what I'm wondering.
this is what you have to work with, that you didn't sign off on it. However, the other side are going to say,
Well, do you think I'll be successful,
you
Neil?
basically,
Do you think you can be successful?
that's a stretch. I mean,
Oh, so you don't think you can? You said there's no written sign-off on it.
yeah, but there's basically just part performance. The contract has been started, and that's what the other side will use. You basically ratified the agreement by performing. Therefore, the non-signature doesn't mean anything. That's what the other side will say.
Well, okay, but so are you telling him he has a chance of winning or not?
Yeah.
You are. Here's the chance.
Yeah, there's a chance, but you don't tell them it's like 99%.
There's nothing ever 99%. So I'll take your money. We've got a chance. Good chance? Good chance?
I think that's where it goes wrong. If you start to just to embellish the opportunities, you got to tell them from the beginning. This is where we stand. If you want to go forward with it, I'll do what I can with it. But I mean, in reality, when you look at this case, they're not taking someone's farm and putting children out. You're talking about two, corporations. There's a lot of money.
Two significant corporations who are business people. They're both, no one's going to bleed for either the Pritzker family or Anthony. So they got plenty of money. If they want to fight it out, what the hell? I got to put kids through college too, right? Right? Is that it? What the hell? It's the worst way to make a living than doing a piece of litigation like this, right? No one's a child rapist here or anything like that. So what the hell?
The client with the white hat, right?
Huh?
You don't always get the client with the white hat.
You don't always get the client with the white hat. But so we're going to take because I see him with the black hat here, and I don't care about the Pritzkers either. But I mean, that's pretty bad language. Get a lousy 750. Back when 750 was something too, right? The lousy 750. How piggish does that make your client
You should
sound?
never have said that.
No, he shouldn't have.
Stopped him from saying anything like that.
Okay, so we're going to go forward on his behalf after cautioning him that he's, not the greatest case in the world, but I think we have a chance of winning. And by the way, so no one's pushed the money back. Okay, and Jim and I have had this conversation in other contexts as well. It's easy for me to tell you, push it back, but I've had to represent people that I didn't care for, or their positions were less than as meritorious as I would like, and especially early on, when you're a low man on the totem pole, you don't get to pick and choose who the office or the firm has you represent. You have to decide, though, to what extent, to who it is you'll represent, because just because you're employed by the office, if you've got some lying, cheating, who's going to drag you into the middle of this mess, you've got to still recognize you got to get out. You can't just because you may have to quit your job. I don't think we're in a situation like this with him, but I mean, you don't have, if you're representing Anthony, you don't have great facts to work with here, because it's really he likes the design, he likes the deal, he just like it to be a lot sweeter, and a lot sweeter when you're talking about a lousy 750 makes your client sound kind of piggish.
That's probably why I didn't get the jury trial.
Among other reasons. Well, and that's let me comment on that. Here's the other part of this that obviously. Well, let me ask you: does this go into your thinking? At one point, Anthony and Thames in Boston was one of the biggest deals ever, right? So, if you can win this case somehow, win the unwinnable case, that's what great lawyers do, right? Your career is now made. You've married a prominent person in Boston who will sing your praises to other prominent people. If you can win this for him, get a satisfactory result, you're off and running. Does that factor into your?
On the other hand, this is another side to that.
There is another side to it. If you trash the case, or if you perform in a subpar fashion, you're done. You may well be done. But if you think that's what you're going to do to begin with, then you're in the wrong profession anyway, right?
That's definitely worth the risk.
It's definitely worth the risk. This is a big return potentially, huge return.
But if you're a nobody, you're already a nobody, so who cares?
That's right. So it's not get any worse. Go ahead.
No, I agree.
Okay, so you're going. When you cautioned him, did you put it in writing, or was that just a conversation as you were taking that $25,000 retainer?
You want something like that in writing.
So you're going to tell him in writing that he's got a bad case?
You don't tell him it's straight up.
Because why am I giving you the 25 grand here now, right? I mean, I know you're telling me that because I would like to hear that you're going to have some caution up front. But remember, that initial exchange is partly where you got to sell me on you, because you're asking me to part with a pretty big check here. And so I got to have some level of confidence, but if you oversell me, and I used to work with a lawyer like that, and he'd bring in clients that oversell them, and somewhere down the road it was a horrendous mess because they want to know where all their money went and why they've got a hopeless situation. And I know where all their money went, and I know why they have a hopeless situation, because they were oversold at the outset. But, so you take my 25 grand, then you're going to give me a letter saying I have a really bad case? Because that's going to either leave a bad taste in my mouth, or I'm going to want my 25 grand back.
No, you have to sell yourself and say, look, this is not a good case, but I'm the guy that's going to win it if anybody's going to win it.
Okay, you think you can win it?
You know what I mean?
You think we got a chance?
You basically tell them you're fighting a losing battle, you know what I mean? But, you know.
Are you going to even say that? You're fighting a losing battle? Do we have grounds for which we can win? My understanding was, I heard that we do, right?
Yes.
We have grounds upon which we can win. What's that thing about statute of frauds? Writing? There's some writing missing here that should have been signed? No? I mean, so we've got grounds to win. And you can't say it's likely we're going to win, and it could be a difficult case.
That's it. Yeah, you tell them the truth.
By the way, did you waive jury because of his potential connections? Did you do that? I mean, is that what it was? Because he was heavily connected. Politicians, if you used to go to Pier 4, the walls were lined with Anthony and various politicians. So, who knows? I'll waive a jury, or maybe the judge would think more kindly of me. And certainly, by the way, the Boston institution, we don't care about a lick about you people from Chicago at all, right? So I've got a home court advantage, huh?
That's got to play a huge part.
Yeah,
So you'd play that angle too? In for a penny, in for a pound?
You know, not what you know.
So it's who you know. So
That definitely helps.
we're gonna jury waive and hope that they says, hey, Anthony, I've eaten there. I was at your time last week. So whatever it is, you're gonna play it all. Whatever it takes to win. Whatever it takes to win.
Aren't 93A claims non-jury anyway?
There are, but there are basic contract claims here too, which would have entitled them to jury, and then what would have happened is the 93A claim is resolved by the judge. So, and it's a lengthy trial, but obviously the jury waived issues. Go ahead.
What was the deal with what he like took everything and like trusted away to his kids at the end? Isn't that
No, not even at the end. Let's talk about that as well. So
they just kind of sent it back down in the lower court to like hash that out, didn't they? Kind of just like, we'll see what you guys do, or?
well, hold on. I'm gonna let's walk through it a little bit, because there's a bunch of things going on there that I want to know if you do that as well. So
It seems like bad advice.
you think so? Well, I want to ask you about that. Hold on. So what we've got is a jury waived trial, which means the case is tried to a judge only, and then at some point there's going to be findings of fact and conclusions of law, and we'll talk a little bit about that. They're looking for expectancy damages, and then we see it as well as there's a question about reliance damages. What's the difference? What are reliance damages? What are expectancy damages?
Expectancy is what you thought you would get out of the deal in terms of your profit. Reliance is what you already spent, yeah.
What you spent prior to the breach of the contract, in which in essence you're out of pocket, right? So in reliance on the contract being performed, you expended X number of dollars. This is what you're out as a result of the breach. The expectancy damages, on the other hand, these are the profits we would have expected. These are the return we would have expected to receive, usually profits, had the contract been performed as it should have been. And so there are significant differences, as we're going to see at the end, as to whether you're seeking reliance damages or expectancy damages. At the outset, you don't have to make a determination as to what you're seeking. And obviously, when you look at the end of this, you can see that it would probably be wise to plead both, because sometimes the case will take years to wind its way through, and you're not necessarily certain which is going to be better at the end of the day. You read why he breached. There was this, in March of '85, Athanas convened a meeting with the fan pier director to express his concern that the project was moving ahead of the Pier 4 project reiterated his desire to have them together. And what really seemed to blow it up was the money dispute, where he just felt he wasn't making enough money. Skip ahead to page 459. Actually, 458 first. That's, I guess, in the fall of '86. Athanas and his development advisor learned that another harborfront deal had been far more lucrative for the landlord than the Fan Pier deal promised to be for Anthony's. So he looks, he gets a little jealous. Someone else is making a lot more money than me. And now he decides he's very unhappy with the deal on page 459. And then it says he retained a new law firm. At least as early as February 17, 1987, Anthony's retained a new law firm. They were retained from the outset to assist Anthony in his efforts to alter the terms of the original agreement. So someone did pass on it.
All got fired.
Well, all got fired. Correct, but where he retains a new law firm, one would think that that would indicate that they may have taken a pass as well. But as you can see on 460, 461, what it boils down to is he wants a better financial deal. And if he doesn't get the financial deal, you've found a way out, which is that there's no sign-off on the contract. Take a look at 462, because here's where the questions that Mark comes on. I want to know whether you do this too. So on January 88, HBC and Anthony's brought suit against each other. So sort of dueling lawsuits, right? HBC sought declaratory relief. What's that? What's declaratory relief?
Isn't that where you go before a judge and he makes a decision for you on a certain issue?
Yeah, that sounds like a D answer.
Of what you're entitled to. The declaratory relief is going to entail what each party is entitled to.
Declaratory judgment is an order from the court determining what the rights and obligations of the parties are to a real or threatened controversy. Okay, it's a classic equitable remedy. And so what they want is a declaration of their rights with respect to the contract itself. They want the court to determine what their rights are under the terms of the contract. They're also seeking damages for breach of contract and breach of the implied covenant of good faith and fair dealing. And I want to ask you about that, as well as restitution, specific performance. You know what specific performance is, right? Court orders the terms of the contract to be performed in accordance with their terms. And Anthony filed suit as well. Better to be a plaintiff than a defendant. He wants declaratory relief as well. Damages for breach of its contractual duty to proceed expeditiously, and if it's covenant of good faith and fair dealing, as well as 93A. The case was consolidated for trial. The trial was bifurcated. What's that mean?
Liability and damages are separate?
Right. So they split the trial between liability first, and the second phase would be damages. If you look at the footnote 15, that's what Mark was bringing up. And I'm wondering about this. It says, on the same day that suit was filed, Anthony's conveyed record title and fan pier to the Fan Yards Nominee Trust. Athanas' 4 sons are the trustees of Fan Yards Nominee Trust, blah, 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 and then it goes on. So you did that too. You filed suit, and at the same time you filed suit, you create a trust to move the largest asset, the asset that's in dispute here, into a trust to make it harder to reach.
Can't do that.
No, you did it, right? Well, Mark, first of all, he says you can't do it. Well, you can, can't you?
He did.
Well, what?
He did, obviously.
Well, you did. You did. He didn't do it. This was something your clever idea came up with. Huh?
No, that's like getting rid of evidence almost. That's like, you can't just take all the funds that are in dispute after right before a lawsuit's filed.
Well, go ahead. What were you going to say?
It seems like a sort of fraud on creditors in a way, because he's moving the assets only in anticipation of having a judgment against him.
Well, let me ask you that, because that's one school of thought. If a doctor came in to see you and said, listen, I do a lot of surgery, I think I should be a PC, I think I should be a corporation so that I don't lose my house over it. You'd set up the corporation, wouldn't you? You might set up a corporation for a lawyer.
Yeah, not if you just killed 3 ladies doing heart transplants, though.
Well, you wouldn't? Okay, so I just killed 3 ladies doing heart transplants. Would you do a PC for me? Would you move my house to my wife? Are you saying no? I mean, so now we're drawing the line. You'll represent those child rapists and all the rest, but oh my God, we're not going to be making assets harder to reach. Seriously? Really?
Yeah, but isn't that kind of overt? Like, you know what I mean? Taking the main thing and just be like, sure, maybe doing a little, like, house cleaning, but I mean, that seems a bit unconscionable. Like,
Is it, or is it preventive lawyering? Listen, when you took that $25,000 check, you didn't think you were going to have to earn it? You didn't think you were going to have to roll up your sleeves and roll around in the mud here? I told you the type of lawyer he was looking for. You seem to indicate you were that type of lawyer. Well, now it's time to roll around in the mud. And all of a sudden, oh no, we can't do that?
I mean, you would do it, but advise him that it's not going to look good.
May not be effective, may not look good, but I'm in.
is that okay to do?
Is that what we're doing? Well, we have a footnote here that doesn't look so good when it's in that footnote that you did this upon the filing of the lawsuit, right? But by the way, do you care at this point? You've already signed on for this journey. You really didn't think it was going to go easy, do you? You really didn't think they're going to say, oh, that Neil, he's just a great guy, great lawyer. They're coming at you hard, right? You're litigating tens or hundreds of millions of dollars cases. If you're in, you better have a pretty thick skin, and you better be prepared to leave no bullets in the chamber, right? I'll move those assets. Good luck. Now there's a way to try for them to come back at it, and they know that. But I'm not going to leave any stone unturned. You can't try to protect them, can you?
I think at one point, if you're being brought in at this point, what time, you might just be trying to clean up the shoddy mess that his previous lawyer made.
That's all. That's all, right? We're just trying to be careful. There is no reason. Listen, any of you bought a new house? Okay, when you do your first P&S for someone who's buying a new house, you better make damn sure the person that you're contracting with is the person that actually owns the real estate. Because the likelihood is that builder has that real estate in another trust of some sort, and then you're contracting with the builder who likely doesn't even own the land at the time he's agreeing to perform in accordance with the terms of the contract for you. It is not uncommon, right? And I think this is part of your job, isn't it, is to set up barriers so that we don't lose everything. You told me you're going to create the PC for the doctor. I thought you're going to move the doctor's house to his spouse or her spouse, aren't you? I mean, that's just good lawyering, isn't it?
But now can't he come back and let's say that it ends up like an ineffective counsel fight? He goes, well, he told me to throw my, you know what I mean?
I didn't tell you I gave it choices.
That's why you put it in writing.
So, because at the point he said, I would rather look at an undeveloped area than
Right.
have them have it. So do what you can to make it more difficult for these guys to get my stuff.
Listen, this is scorched earth at this point. He's decided that. I'd rather look at nothing than a lousy 750. He's driving the bus. You're in the passenger seat with him.
Well, that was his kid, though.
Goading him on. No, that was him who said that. So, but you're in. I don't know why you draw the line on this. It doesn't look good, by the way. You're right. It sounds terrible, but what the hell? I've set up another barrier. That's what I'm supposed to do. Listen, you went in and found you manufactured a breach of contract. Now you're going to start to worry about, oh, this looks bad? You've got a client who looks bad. He wants a defense. He's prepared to pay for it. You've found an argument consistent with Rule 11. In for a penny, in for a pound.
It looks bad from the outset anyway, so what's the difference?
He does look bad, that's right. I'm not going to make it easy for you to seize this asset, which is a huge asset, right? That's, frankly, not moving it, not taking steps might be malpractice. You have to try something. You have to create these barriers so that they just can't come in automatically and take everything he owns, especially what they're looking for. It's going to be a problem because the reason the footnotes there is it says, Jesus, he really does look a little sleazy here. I think that's also why they told us the other firm was out. They're saying this is not his finest moment, but obviously you have a client that isn't his finest moment, and he's still looking to make a better deal. And frankly, there are some businesses that they expect litigation will be a normal cost of their business, and if he could make $1.5 million as opposed to $750 simply by spending $100,000 or more with you, that's a great business deal for him, right? If he doubles his money annually simply by an investment of $100,000 or $200,000 in legal fees, it's money well spent. What I'm hearing from you, it's money well spent, right? He's made his business more profitable. So at any rate, phase one, the liability trial. The judge ruled that Anthony's purported disapproval of the development plan was a breach of both the express terms of the agreement and the implied covenant of good faith and fair dealing. This covenant of good faith and fair dealing, at some point, don't you also, as his lawyer, say that there is no covenant of good faith and fair dealing between business people? Because I'm looking, go ahead, what?
If they're sophisticated business people, they should know what they're getting into, but at the same time, you would still expect that there would be good faith on both their sides. So,
but this is the argument you made as his lawyer, right? Look at page 473. Anthony asks us to hold that in contracts, and this is what you just said too, contracts between sophisticated business people, no covenant of good faith and fair dealing is implied. That's what he says. That's what you said, because you were his lawyer. You can make that argument with a straight face. There's no covenant, and you, by the way, he has no authority to support it.
Yeah, because there is none.
Because there is none. And the decision goes on to say, indeed, the rule is clear in mass that every contract is subject to an implied covenant of good faith and fair dealing. So you made that argument too on his behalf. Between two business people, sophisticated business people, as these two both are, we can cheat each other if we want. That's a tough argument to make. It's certainly a tough argument to make with a straight face, and it's worse yet that you have no authority for it. You're just making your situation go from bad to worse.
Anthony probably told his lawyer to say that.
Well, I think either that or you decided to come up with this little gem on your own. Either way, it doesn't really make you look very good. They try to mediate to some extent this dispute at some point. And the judge, him or herself, it was Judge Abrams, trying to work with them. And then at the end of the day, there is no resolution. The judge has to make, in a jury waived trial under Rule 52, you must make findings of fact and conclusions of law. And the findings of fact and conclusions of law, you submit to the court, proposed findings of fact and conclusions of law. Oftentimes, the court is likely to adopt many of your proposed findings of fact and conclusions of law, assuming that they are supported by the record. And findings of fact have to be supported by the record. By that, what I mean is that you have to go through the transcript of the trial and actually provide the record references as to where this information is. So if we want to say, whatever fact you want to say, it's a detailed and exhaustive process where you've got to go in and find out where that evidence came in. Where did the witness say X or Y or Z? That's the findings of fact. These are the facts I find in arriving at the decision. The conclusions of law are simply the law that is important in resolving the controversy. At some point, if I submit appropriate findings of fact and conclusions of law, and consistent with the evidence that's introduced at the trial, there is a likelihood that the court is going to adopt many of mine, if not all of mine, and especially if the other side is less reasonable, their findings of fact or law may not be supported either in the evidentiary record or under the Massachusetts law. What he's saying is, geez, they seem to take the other side's completely. Well, he seems to be going the other side's way completely here. The findings of fact and conclusions of law have to be made by the court, but it's not unusual that they would adopt many submitted by one or the other side. Oftentimes you would see it as a combination of the two at some point that emerged. Sometimes the court will just adopt them on their own. But under Rule 52, they must be made in a jury-waived trial. And so you should be careful to make sure in a jury-waived trial that you submit proposed findings of fact and conclusions of law. Almost always the court is going to require them of you, but even if they don't, you want to submit them because then at least you have, you've made the judge's job easier to find for you. That's what we always want to do. However we can make it easier so that we win and they lose, that's your job. To the extent the other side doesn't submit proposed findings of fact and conclusions of law, it makes it very easy for the court to adopt mine. And the fact is that that's going to be the basis for whether the judgment is sustained on appeal. So to the extent that you can make it easier to reflect the best parts of the record that support why you should win, then you should have done this. And here it says the record does indicate that the judge revised HBC's proposed findings and conclusions in some way. He did adopt many of them. And there's nothing wrong with that, as the court says at the end of the day, especially if you start to think about the manpower resources, certainly in our state court systems. Was only up to a year ago where there were mandatory furloughs still within most of the courts, where people were working 5 days and getting paid for 4. The fact is the judges don't have a lot of resources, so to the extent that you can make that technology available to an easier extent, you'd be a fool not to do so. Federal court has more resources, but it's still, anytime you can make the court's job easier, that's what you should be doing. And this is a 79-day trial here, including over 1,000 findings of fact and 35 rulings of law. That's footnote 39. 20. This is a huge case, which would take an enormous amount of work. But obviously he's got lots of lawyers, and so does the Pritzker family have lots of lawyers that they're paying enormous sums of money here for, so that they can put these findings of fact and conclusions of law together. Let's see. Yep.
In motions class yesterday, we were talking about how some judges are asking for those proposed findings before the trial.
Yep.
How does that work when you don't have a transcript?
That's a great question, and a lot of courts do. I think you need to think about it this way, first of all, because I've done both, and sometimes I will do both, period. I'll give proposed findings of fact and conclusions of law at the outset of the case. When the case is over, I'd ask the court for 30 days, get the transcript, and now add record references as well, okay? And here's the way to think about this. There's a couple different things I think about with that. Let me answer Brenda's point first. When you go in to try the case, you should know what facts you have to prove in order to win, right? Because if not, you shouldn't be trying that case. The second part of it is you should know what law is dispositive of the facts that you're going to introduce such that you should win. Again, or you shouldn't be trying the case, right? And so you should be able to submit proposed findings of fact and conclusions of law before you ever try the case. And the reason you should is because those are the facts you intend to introduce, and the reason you do is because this is the law that supports why you should win. So you should have both of those sets, and frankly, it makes you a better trial lawyer to have done that in advance, because now you know exactly, and then you can sit there and check off as the evidence comes in exactly what facts you've got in the record. If you don't do that, there's a chance that you could miss essential facts that need to be proved. Sometimes in evidence, we've read a case where one of the cases was that they didn't put in evidence that the defendant who committed the bank robbery was at least 18 years of age. Now, that's obviously a pretty basic thing that you would think they should have introduced. But if you don't think of it, but the guy's 36 or 37, so you say, well, what the hell, why do I need to? Well, you need to because it's an element of the offense. Same thing with if someone's arrested for DUI, that they were on a public way. If you don't introduce that evidence, then it's potentially going to be directed out on a required finding of not guilty because it's an element of the offense. The same thing happens in civil cases. In order to win, there are facts that you have to plead in your complaint, and ultimately offer proof on. So a lot of courts will request, frankly, even if they don't request it, practice has been in many cases is to submit proposed findings and conclusions at the outset. Or certainly what I always call a trial memo is, okay, I'm going to try the case, but here's the important facts and here's the important law to understand. The reason some courts want it at the outset is so they can be looking at the conclusions of law during the pendency, while the evidence is coming in, to determine what evidence is more important than others, and see if they agree that that's the appropriate law. Because that's the other thing is, I'm telling you the law I say is applicable. The other side is going to give us different law that says the reasons they should win. So the court does have to sort some of that out. At the end of the process, when you now have a transcript and you have exhibits in the record, that's when the proposed findings, that's when you can, again, and I would ask the court to give me 30 days to submit more detailed proposed findings of fact and conclusions of law with record references in it. So now the court can go right to the transcript and see where that evidence is. It's not just me saying, just take a simple divorce case. The parties were married on April 1st, 1990. That's a finding of fact that has to be made simply because if we're going to divorce them, we've got to show that they were married. Okay? So at some point, either the marriage certificate's going to be in, or we're going to have testimony concerning it, whatever it is, then at some point will be a record reference to where that is, where the proof of that fact is in the record. And it makes more sense then, even if I've done it at the outset, to now provide that additional tool to the court, because again, any time we can make it easier for us to win and the court to find for us, that's what we're supposed to do. Because people, for the most part, are lazy. And so you want to make that job much easier, and that's what we do. In a related issue, and I keep saying this, and I don't do it, I don't follow my own practice. When you are doing your initial investigation of the case and researching the law and all the rest of it, what you really should be doing is you start to think about taking civil cases in and getting them, ready for trial through discovery and the rest. Is you should, at that point, at the very outset, look at what the likely jury instructions are going to be if it's a jury trial, or what the likely conclusions of law are going to be if it's a non-jury trial. Right? What is the law? Now we do that. We do that at the outset. We research the law. But we really should do it to a better extent and say, well, what are specifically the instructions that the jury is likely to receive? And then tailor a lot more of your preparation and discovery towards that end. We all research the law at the outset to figure out what we need. There's one more step there, and think about it. It's the process of, well, what is specifically the law they're likely going to get at the end? And what's it going to say? Because maybe that'll help shape your thinking at the outset. And that's really what conclusions of law are in a jury waive trial, or jury instructions are when you have a jury trial. And that's why courts want them. Oftentimes they will ask for them at the beginning and then at the end as well. And it's obvious. It's actually easier to write them at the beginning. It sometimes depends on the length of the trial. Even in summary judgment situations, the court will does under Superior Court rules, wants record references to what we call a combined statements of fact. If you've got a lot of discovery, that's weeks worth of work to go through all the various depositions to pull out the facts that are in dispute or the facts that aren't in dispute with specific references. It's easy to say, the parties dispute that there's a valid contract. Well, that's probably BS. But say Anthony says, I never said the lousy 750. Well, there's got to be a record reference somewhere, and now we got to find it. That's one of those that I'm sure you keep track of. There's a lot of others here, the more little, smaller facts, that there will be times, we've done this. I know I saw it. Where do we see it when we've got a record that's a couple hundred pages long? If you don't keep track of some of that information, you're spinning your wheels because you've got to go back and find it. So there are findings of fact and there are conclusions of law. I asked you about Anthony saying that there's no covenant of good faith and fair dealing, and you just saw mass law that says there's every contract in Massachusetts has a covenant of good faith and fair dealing. And now let's look at the 93A. HBC says that Anthony's conduct amounts to an unfair or deceptive act or practice, and therefore the judge erred in denying their claim for damages under 93A. And the appellate court agrees with them. The fact is this was unfair and deceptive. Even if it's practiced among two business people, the fact is that there are unfair practices that Anthony worked here. If you look at page 475, and there is a different standard, though, for 93A damages when the practice is against a business as opposed to what they call a commercial innocent, a consumer in essence. So two business people, they use the phrase rascality here, which the court no longer really uses. But they say that it has to show a greater rascality of the activity. And what they really are using now for the terminology is that there has to be a greater level of unfair and deceptive nature to the practice when it's practiced against a business as opposed to an individual. At the end of the day, the court has no problem finding that Anthony's practices here would raise the eyebrow of those inured to the rough and tumble of the business world, because he really just got piggish and wanted more and more money and manufactured various reasons why you manufactured those various reasons why you didn't want to perform. And the court doesn't find that any of it was advanced in good faith. It says the judge awarded HBC $42.6 million in expectancy damages, and in the alternative, he ruled that HBC is entitled to $14.5 in reliance damages. Pretty significant difference between what expectancy damages would be or reliance damages. So which one do you want? Huh?
Lesser.
Well, if you're Anthony, you want lesser. If you're HBC, which one are you accepting? Can't get both. You're taking the 42, right? That's your choice. That's why you plead them both. You're not sure at the outset necessarily which one's going to be better. Maybe your proof will fail on one as opposed to the other. So you plead them in the alternative. But when you look at those numbers, it's clear which one you're going to take. And that's the thing. You don't get both. You don't get 42 plus the 14. You get at some point, you got to pick which one you want. And obviously, you're going to take the expectancy damages. And so this is a significant amount of single damages. And the appeals court said here, the aim in measuring damages in the event of a breach is to place the injured party in as good a position as he would have been had the contract been performed. That's your expectancy damages here, and that's what we're looking at. Anthony wants to say, oh, lost profits are too speculative. The court doesn't agree here at all. They've got expert testimony on valuations and the like. He's, at this point now, you're desperately trying to make an argument to try and do anything to try and reduce your damages. If you look at page 487, at the conclusion of the Phase 1 trial on liability, the judge issued an interlocutory order enjoining Anthony's and the fan yard parties, among others, from conveying, leasing, or otherwise alienating the fan pair property. And then just before the Phase 2 trial and damages began, HBC sought to raise the issue of the validity of the conveyance of the Fan Pier property, the Fan Yards Nominee Trust, and said he'd wait till do that on the end. That's my point. If there's no injunction prior to the transfer, there's nothing that prohibits you from doing it. At this point now, there's an order that prohibits them from transferring it any further because the court has found liability, and obviously you'd be in contempt of court to try and move that property in any further way. But even at this point, the court doesn't want to address the issue of what you called correctly a question about a fraudulent conveyance or a conveyance in fraud of creditors, which, by the way, that's another action the court has the ability to set aside if they thought this was done as a fraudulent conveyance, either to do it in fraud of creditors or one that would leave him with no assets. But again, that's an issue you have to litigate. I think it's likely you're going to succeed, but you've got to be careful on it here. That you do get an injunction at the end of phase 1. And so tell me how much he ultimately loses here. Because if it's double or treble damages plus attorney's fees, then we're looking at well over $100 million in this judgment, right? Because did you tell him that? That's probably something I might have liked to know. Can't possibly have thought it could get this bad, did you? Because you know who he's looking at now.
That's why you put everything in writing at the start.
So you did put all that in writing, that you could lose $100 million. Did you tell me, did you really say that? Because I didn't hear anyone talk about those numbers like that. Because that's probably the type of number that would get my attention. Even someone like him would tend to get attention.
Well, I don't mean that specifically, but you put in writing what you think the outcome may be, or how you perceive the chances and what could go wrong. And like, you're not going to guarantee anything.
I remember you not guaranteeing anything. I remember I thought hearing that we have a chance of winning, and I didn't hear anything about a chance of losing $100 million.
You said you wanted a parking lot.
But now I'm not even going to have a parking lot. Right, I've got $100 million. I didn't hear anything like that. Because don't you think that's something you should have talked to me about?
Yeah. Because
you didn't. You said we might not win. I didn't hear anything about losing $100 million. Shouldn't we have had that conversation? Because he's now coming at you, isn't he? I mean, listen, he's willing to take on the Prince because you're just some schmo. You must have a liability policy. It's not going to come anything close to this. But
that's why you're going to warn them up front. Say, look, this 938 claims, we could lose triple the amount that you really want to lose, or it could get bad. I mean, you have to tell them it could get ugly.
Oh, this got more than ugly. You've lost $100 million. You've lost $100 million case, right?
Plus, we think the legal.
I mean, seriously, this is a monumental loss, and you didn't say anything about this. You didn't, did you? So, do you owe him money?
No.
Oh, no? You don't owe him anything? You didn't owe him better advice at the outset?
Maybe a better warning, but no.
Goes with the territory. He's a pig. Pigs get slaughtered. It's the way it is. With no one, and I don't feel bad for him either. No one feels bad for him. But you made a fortune on this, and that's all good too. Because you must, a case like this, you probably made, or the firm made a couple hundred easy. Maybe a 79-day trial.
He's still got all that land. He's going to find another buyer for it. He might still come out ahead. This is 5-6 years later.
Well, you want to know how the story ends? Because, like most of us, would be licking our wounds, sitting down some dive bar and lay at the back of the bar in soiled clothes and everything else. But Anthony had friends, I told you, right? So who ended up buying the land and bailing Anthony out?
State.
Federal government. What is on at least a significant portion of Anthony's land now?
Moakley Courthouse.
The Moakley Courthouse. So funny how that has that name, huh? Moakley Courthouse now sits there. It's one of the most spectacular locations in Boston. The courthouse is spectacularly beautiful.
What about the Museum of Fine Arts? Is that on his property too?
No, the Institute of Contemporary Art is next to it, but not the Museum of Fine Arts is over in the Fenway.
That's what I meant. I mean,
Yeah.
So
Yeah, no, I don't think that's his. His is well, that would be part of his. His is further down. He got bailed out by the federal government to a significant extent. I think the federal government actually just bought a portion of the land, which was enough to be able to take care of the Pritzker judgment, and he still was able to retain much of his land. And obviously now the seaport is flourishing. So where most of us would have gone bankrupt and licked our wounds, even as bad as this was, it was probably maybe more financially profitable, even losing this type of money. It seems hard to believe without knowing how much money he could have made on the rest of this. But the fact is that, as it turned out, even with a devastating judgment like this, he still ended up more on his feet than the rest of us would be because of his fairly influential friends.
What about the firm that represented him? Really, what happened?
I don't know. The first firm also did some work for the Patriots at one point. I don't know. I'm trying to remember who the... Joe Kozol.
Yeah, the seaport now is crazy. You can't even see the water here.
Nope. I don't know who the first firm was that negotiated the contracts either. Okay, so and we're going to do the other case in the packet. Talks a little bit about more of these franchise issues. And we talked a little bit about that the last time and the requirements of the disclosures and everything else. The last case in this section 3 is Zapata versus Dairy Mart, relatively modest franchise case. But he's got a contract, and again, the contract says that they can terminate it upon 90 days notice. And they offered him the opportunity to buy the stock back at a price. He didn't want to do that, and at the end of the day, they wanted him to sign the independent operators agreement, and what he says ultimately is that he's forced out because of unfair and deceptive trade practices. But Dairy Mart says, well, this is a provision within the agreement. You signed it. You're a big boy. Out you go. It says here he declined the opportunity to take the agreement to a lawyer for advice. He had ample opportunity to consider the agreement before they signed it. He ultimately does sign it. And now he says, well, that's not good faith. And he says he tries to argue that they're not free to terminate it, even though the terms say that they can terminate it if they choose. You going to throw him out of his store? Huh? They did? You did. Someone's got to represent Dairy Mart. They gave him opportunities. He didn't follow the advice. He didn't think of what he should have done. He signed a bad deal. The deal says he can be out in 90 days. He's out in 90 days. Who cares?
You should have done a job reading the contract.
Go ahead.
Well, I don't know how thick of a packet that he had when he read through, but they said right from the outset that his biggest concern was having stability. And if you see a clause in a contract that says we can terminate on 90 days notice without cause, that should be a red flag right away. And he should have at least attempted to negotiate that portion of it, but it seemed like, I forget what he had a problem with, but it wasn't that part.
Is it 90 days after a year?
One of the places he
I think that's right.
I think he said in that place he can call his own, but
He could get out himself.
Put that name
Was it
on.
double?
He could get out as well. That's right.
And it seemed like they didn't bury it either in the fine print, because they mentioned how it wasn't buried in small print or in hundreds of pages or whatever the wording was, but it seemed like it wasn't. It could have been, but my reading of it kind of pointed like he's an idiot for not doing that.
But I don't think that's why they threw him out. Though. They threw him out because they changed the contract, which he wouldn't sign.
Yeah.
Right.
So they tried to change the deal on him.
But he switched stores too.
But he did have a deal that said 90 days notice and he's out. So he's out, and there's no lack of good faith there.
And then the fact that they changed the contract was bad faith.
We'll say what?
The fact that they changed the contract is bad faith.
But the court doesn't seem to think it is. Actually, they didn't change it. They tried to change it. He refused, right? And so they went by the terms of the existing contract, which says, okay, don't sign it. Here's your 90-day notice. Goodbye. That doesn't seem harsh. Doesn't seem like a breach of good faith.
That is harsh because the real reason they didn't sign the renewal contract is because he didn't sign the revised contract.
Because otherwise he'd still be there.
Otherwise, he
So they tried to change the terms on him. He said no. They said, okay, the existing terms give us a basis to throw you out. You're out. And out he goes.
which is true, but that's not law.
It's the nature of a franchise.
Well, it's the nature of a contract, right? If the contract by its terms says that we can do certain things, you can see what those terms are, and the fact is that it may seem unfair, it may seem harsh for him as he sees it, but to some extent, you signed the agreement. Even if you make a bad deal, then you got to live with the terms of it. If you make bad choices, you got to live with the terms of it.
He made bad choices right from the beginning. Why wouldn't you have a lawyer look at it? All he had was like a couple of business classes and 1 year of college, and you're just going to put your life into a franchise and not have some companies to tell you what your risks are with this contract and whatnot.
But you know what? Go ahead, Charlie.
I think it's kind of funny because I went to business for my undergrad, and they emphasize how he went to business school and whatnot. I know a lot of people graduate business school and don't know anything, nothing, and I don't know. They kind of keep pointing at like he should have. I think he still should have read it. You don't have to be a business major to read, but.
But they're not going to read it like a lawyer, right? They're not going to read it like you, looking for your deal breakers, looking for those hidden traps, because we're cynical, nasty people, like we saw in the last case. You guys read with a more careful eye. But tough luck.
I mean, isn't this classic buyer beware? They just don't look. This guy is he wants this dairy mart so bad that he doesn't won't even take the information to a lawyer. So think about that for a second. I mean, and basically it is buyer beware. I mean,
but you know why they don't come to you, right? Because you are the deal breakers. You are the dream killers, right? You're the people that find those little picky little problems in the breaches. Why am I going to go to you, pay you money to tell me to kill my dreams? To say don't sign it, don't do it?
Yeah, this ain't a big business deal. This guy's a ton of money either.
Well, but this is his life. When you say it's not a ton of money for him, this is what
I know, but he's not like some big company that's gonna have a lawyer look at it. I mean, he's just a guy who wants to run his market. You know what I mean? He's not gonna have a lawyer look at it. Plus,
well, but he should have a lawyer look at it, right? Because we're all looking at that, saying, "Well, you should have a lawyer look at it," and saying, "Well,
when you buy a house,
huh?
You have a lawyer look.
You should have a lawyer look at it when you buy a house. There are people that don't. The broker puts it together, and then when the deal hits the fan, they come see the lawyers.
The biggest problem that I had with Dairy Mart was the brochure that they brought up like twice in the thing. And it mentioned at the beginning how it said, it gives the whole rant about an opportunity to own your own business, and we can take the tools we offer and build a life with security and comfort, and that's so far from the truth.
No, but that's the dream. People are buying in with this, right? I get to have my own business, but I get help running it. That's why people buy into this. And having looked at some franchise agreements, you would not believe how significant the provisions are within it. Seriously, I don't know what you'd really charge to go over something carefully, because they're yay thick. I mean, they're at least half a dozen hours worth of work. So you're looking at $2,500 before you really even start to do much with it. And some of it is just boilerplate, there's nothing you can do. But the fact is, if they're going to sign it, you better be able to tell them, look, there's a 90-day provision here, there's a forfeiture of inventory, there's whatever is there. And this is the problem, though. They're scraping together to put a business together, and now you want another $2,500 to tell me that it's a bad deal to begin with. That's why a lot of people say, oh, I'll just try, especially if the initial investment is relatively modest, as it probably was for a Dairy Mart. It's not the $1 million for a Dunkin's or McDonald's. People, and this is where they do save. They save when they're buying the house. They save when they're doing this, and then all of a sudden, when it hits the fan, that's when they come and you look at the paperwork and say, oh my God, what have you done here?
You say that people go into these with more open eyes nowadays, though? I mean, like, they're a little more aware of what franchise can do, but no.
I don't think so. I think this is something that's been going on forever and a day, and it will continue to go on. And a lot of it is exactly what happened to Zapata. It's something you want so bad that you want to just believe whatever you see, that everything is going to be fine, all you got to do is work hard. And then you get trapped in these things. There's not a crew of people that are wiser now, I don't think, to illegal terms or anything.
They have these franchise expos all the time. And I mean, it's at the Shriners here, and so I think it's a good business. I mean, I think it's a good business to run the expos, because I think we should actually get some more modern literature on it. My guess is that still for individuals, it's probably I don't know what number on the list it would be as to how they go into business, but pretty high. So they are selling the dream, and that's the problem is people are still buying the dream, and then they get into these agreements. So let's take a quick introduction to Rule 11. Rule 11 requires you, and it's not just Rule 11 that you need to start to think about. You need to start to figure out in law school, what cases and what are you going to need for support for these cases that you're willing to go forward with, where you're going to draw the line. We had lawyers a number of years back, not that many years back, arrested down Lawrence for assisting with perpetrating fraudulent claims with chiropractors from auto accidents. It's not just this area, but it's many other places. And I think it's very easy sometimes for you to get swept up into some of these issues simply because with the crush of work and the desire to make money, you don't necessarily dot your I's and cross your T's. And then all of a sudden you're deep in a situation that you had no control over simply because you weren't sufficiently careful and you rushed off to file suit. And so Rule 11 requires you to make an investigation both legally and factually into the claim's merits. And what that means is that you need to talk to the clients, to witnesses. You need to look at evidence. The fact is if you went forward on the last case knowing, or not the last case, but Anthony's case, knowing that he said, I'd breach the agreement for a lousy $750,000, that should have required a real heart-to-heart talk there. And hindsight says it's $100 million. So I'm not trying to be too preachy about it, because I wouldn't have turned him away either. I look at a contract. He hasn't complied with the full terms of the contract had not been complied with. I wouldn't have had a problem initially starting suit on his behalf, seeking a declaratory judgment. I think at some point there were probably terms to settle on that would have been more advantageous for both sides than to expose it to $100 million. But you don't know whether the other side wanted to do that either. But at any rate, when you are involved in it, you've got to make sure that you've got sufficient support. And no matter how much work you do at the outset, there are going to be surprises that come down the road. What you want them to be, though, is hopefully relatively modest surprises, and not that much of it has been fabricated and the like. Unoil versus Hutton is the case I wanted you to look at. It uses the old Rule 11, which is not that different, but there are some changes, such as what we call the 21-day safe harbor provision now, which means that if you get a letter from the other side telling you that you're in violation of Rule 11, they give you 21 days to withdraw the pleading before they can seek sanctions. It's a lousy way to go if you're going to then withdraw it because they felt you violated Rule 11. But it's certainly better than being hit with sanctions. This case, the attorney that signed on was an attorney by the name of Joe Alioto, who used to represent the Patriots as well. He was former mayor of San Francisco, and he relied on the representations of another lawyer that the claim was sufficiently meritorious. Can I do that? No? So if one of you call me in a few years, you got a really good case, and you say, really, Professor, I've got a great case, I need some help, we'll both make a lot of money.
You should know better.
I should, but I don't. So what do I have to do? Do I have to look at everything?
I think it depends on the relationship you have with that attorney. Some attorneys have a very good relationship and they know that that person's going to be thorough in the details based on how they've worked in the past. They feel.
Is that going to be enough if the spit hits the fan?
No.
Right? Okay, Brenda and I have worked on 3 cases in the past. Everything's been great. All been supported. Number 4, I say, yeah, sign my name to that complaint, Brenda. Am I okay?
If you don't know, can you have the plaintiff do a verified complaint, have them put their name to it?
Okay, but even when the plaintiff verifies the complaint and they are swearing to it, that doesn't absolve you from Rule 11. That's their jurat. You're still signing as the advocate, as the attorney. And even if they've sworn to it, if there's no support for it, legally or factually, you're still subject to Rule 11, big time. So that's the problem is, and listen, a lot of times, oftentimes they are going to tell us that their claim is meritorious, and the facts will be tilted in their favor, right? That's the way they see it. So that's why you got to take a step back and say, well, what support do we have for it? You know, frankly, you could have a he said, she said case. Your client might be 110% correct, but if there's no evidence that supports it, then maybe it still isn't sufficiently meritorious to go forward, even though they're right. What your obligation to do is make sure both the law and factually that claim is sufficiently supported so that you can feel it's meritorious. You'll go forward with cases that you don't think you should win. The question is there a basis for which they should win? Because you're not always right either. What you shouldn't be going forward on cases that there's no evidentiary or legal support for. And in this case, as you saw in this case, what happens is this guy didn't buy or sell during the relevant period. He held. He wasn't injured at all. This person never should have been the plaintiff. And Alito never should have signed the complaint. So tell me, when one of you call, what do I have to do? You say, I've got a stack of research yay thick. Do I got to look at all of that? Sure. I do? All of it? Or can I just say, give me your 10 best cases? Give me your 10 best, your 10 worst cases. I can't do that? Give me your best witness statements. Give me your worst witness statements. Are you really telling me? Because some of these cases, it's that all that before I even get in.
But they may be the best 10 cases in the other attorney's eyes. You might not see them the same way, so you should. So
I've got to check every piece of research you did. You guys have done legal research, right? A lot of times you pull a case and say, it's okay. I got to read the it's okay ones.
You got to do your own investigation.
So even if you give me your 10 best and your 10 worst, I still have to double check the research. I don't necessarily. There's 100 cases. I can look at the 10 best and I can look at the 10 worst, and then I got to do a little of my own.
Yes.
Do we agree with that? So I don't have to look at everything, but I've got to look. I've got to do my own investigation, even no matter how many times I've worked with Brenda or whoever it is. Right? That's what the case says. It might be nice to think you can rely on someone else. And by the way, you really can't, right? You can't and shouldn't, because no matter how often you've worked with them, and there will be people where I will trust more, and so maybe my inquiry will end a little sooner because I feel more comfortable with what's likely been done, but you've got to do it. You can't rely on someone else no matter how often you did, and frankly, you shouldn't. Because maybe they're wrong this time. Maybe the instinct. Maybe there is limited support for it. The fact is, Rule 11 is your signature on that pleading that you have made that investigation, and it's not interposed for any improper purpose such as harassment or delay. And there have been cases where I've come in to help, and our case, I wish I never had come in to help. And I'm not sure we could have discovered it before, but the clients were just liars. Liars, pathological liars. Every time the other attorney told me something, I said, no, that can't be true. I go to the client and say, you know what he said? She said, oh, let me explain that. And I'm thinking, one of these times, can you just say, that's not true? You know, but it never was. And finally I said, we're done. I'm done. I'm not trying this case. You're gonna take whatever settlement offer they have because you're just liars. And I'm not sure that could have been discovered better beforehand, but I was in part relying probably too much on someone who I trusted more than I should have as to having made a better analysis of their own credibility and factual support for the case. Usually I'm going to do what we just said. I'm going to look at the 10 best, the 10 worst. I'm going to do my own research. I'm going to look at what we've got. You've got to do your own Rule 11. I'm not going to look at every case you ever pulled, because we've all done that. I pull and copy cases and then I put crappy case, right? You know, I'm not going back to read it again if I've made that analysis, and I shouldn't have to do that for someone else, because there's a lot of excessive stuff that you just don't need. Problem is, Alito did nothing. The reason I wanted you to read this is he's the former mayor of San Francisco, one of the greatest antitrust lawyers of his time, fined $300,000. What would they do with a schmo like you? Okay? And that's what I want you to think about. This guy, who was really well regarded in the field, was sanctioned $300,000 a long time ago. These numbers can be huge. I was just doing bar exam boot camp last night with the students. There was a sanction of $5 million to the corporation and the attorney. $5 million.
Rule 11.
Rule 11 and 231(6)(f). There's a statutory, Mass, we have both Rule 11 and a statutory equivalent, which is called 231(6)(f). $5 million.
Did he do something really egregious, I hope? Or?
Well, there was the destruction of some information and the like, so it was egregious. And by the way, your liability insurance doesn't cover Rule 11, so don't think that that's